Not everyone is connected yet. Okay, it appears everyone's now connected. This is JLLJ Development LLC et al. Versus Quad Casinos Gaming Authority, docket number 21-189 CB. This is the time set for hearing on the plaintiff's motion for settlement and entry of order. I'll take appearances first for the record, starting with the plaintiff.
Michael Perry, Your Honor, for the plaintiffs. I'm not sure if Andy's on. He's traveling or out of town today, and he may not be able to connect.
I thought I saw him. Yeah, he's here.
Oh, okay.
Mr. Broder?
We might have lost him.
Yeah, or he might be the one who I just let in on an iPhone, and the iPhone's still connecting.
Oh, I see him. Yeah, there.
Mr. Broder? Mr.
There
Broder?
he is. You might be muted, Andy.
Well, I think we lost him. Okay, so I'll go on to appearances for the defendant, please.
Thank you, Your Honor. Jeffrey Rasmussen for the casino.
Okay, so Mr. Perry, were you prepared to argue this? I think Mr. Broder might still be trying, but I'd like to proceed.
Yes, I can do that, Your Honor. Thank you.
Go ahead. Go ahead.
Thank
please.
you. Your Honor, the purpose of today's hearing is to determine whether the order that the plaintiff submitted comports with the trial court, with the court's prior decision under MCR 2.602B2. That is the fundamental question before us today. We've not heard any objection from defendant that the proposed order fails to comport with the court's decision. Rather, the defendant has disagreed with the court's ruling. We understand that the defendant has the right to do that. There are proper forums for the defendant to express that disagreement, such as a motion for reconsideration, such as an application for leave to appeal. However, since we're still in Your Honor's court, the only question before us today is whether our proposed order comports with your decision. And we believe it does in all respects. And again, we've not heard to the contrary from the defendant. So unless the court has any questions for us about the proposed order, we would simply ask the court to enter it because it does in fact comport with the court's February 9 decision.
Thank you. Mr. Rasmussen?
Thank you, Your Honor. We have two primary issues with the, or three primary issues, I'm sorry, with the proposed order. The first one is, again, that the plaintiffs are submitting false affidavits to this court, and we don't think that is appropriate. Here in their motion to settle the order, they said that we had not responded. That was simply false. We had said we planned to take the full 7 days that we would object to the order. They went ahead and then filed the order, and that's fine. It's a little questionable under the court rule whether they can do that without waiting the 7 days to allow us to provide more detail of our objection, but we're not going to object to that. But what we don't like is for them to file that and then say we hadn't responded when we had responded. We had said we are going to be objecting. And they tried to make a bunch of hay out of that false allegation yet again. And it's getting a little tiring that we have plaintiffs simply making up the facts that they want in order to try and paint us in this improper light. So that's the first problem we have. with it. Going to the substance, though, our objections to the proposed order are that it doesn't include all of the court's orders. That it's not, an order shouldn't just be, this is what the plaintiffs want to have ordered. It should be, this is the other rulings that the court made. The court, as we run through in our objections, we made a number of objections at the hearing. The court ruled on those, on some of them. On others, it didn't rule, but on some of them it did rule, and those should be incorporated into the court's order. For example, we objected based upon lack of jurisdiction. This has been an ongoing issue that we can't get the court to issue an order saying it has jurisdiction. We objected based upon immunity. We objected based upon the tribe's statutes that the court order is imposing obligations that it lacks the authority to impose against a tribe. It is ordering the tribe itself to take various actions on the tribe's reservation. It's ordering Keewaydin to take various actions on the tribe's reservation. And there's a process that has to be gone through in order to be able to do that. So those were things that we included in our argument. All we are asking is that the court augment that portion of the order in order to discuss its rulings on the various issues that the casino raised, and also to include the issues that the casino raised that the court chose not to rule on. So, for example, we asserted that in a motion for contempt in this particular type of a situation, the court should have deferred that to a different judge. The court didn't mention that at all in its oral statements, but we would ask that the court's order say either provide the court's ruling on that issue, or at least acknowledge that this was raised and the court didn't respond to it. What we need, when we go up on appeal, what we need is an order that includes all of the court's order, not just the part that the plaintiffs want, so that we can have adequate appellate court review of that order. And that's part of the point of that. And that's why we objected, provided the proposed or the objections to the proposed order asking that it be augmented. And then the last point that we raised in our brief is, our view is that the $1,500 that the court imposed, that what we need to do with regard to that is something different than what we're doing. As we discussed in our brief, and I think the court probably by now has received, that we have submitted the $1,500 to the court, asking it to place it in its registry so that that money can be there. We expect that the $1,500 is going to be reversed on appeal for the same reason the court refused to impose the $2,500 that the plaintiffs asked for at the last hearing. That when we're dealing with a request for attorney fees, Michigan case law is very clear that the court has to take the facts related to that, has to, like in this particular case, then plaintiffs submitted 20-some pages, I think, of documents to try to justify their $2,500 in requested fees. But for the $1,500, there wasn't that. And the case law in Michigan then says, well, if that's what we have, if that's all we go up on, that will be reversed. So we don't want the $1,500 to be placed in the hands of the plaintiffs, given that substantial infirmity in the order. And then also the plaintiffs, by choosing to come to court and ask for a settlement of the order, our position is that any due dates would have to come after the court issues its order, so that we can have an orderly method of proceeding. We can't appeal until we get a written order from the court. And by submitting the request for a proposed order, the plaintiffs effectively cut that off, but they now need to deal with the consequence of that, which is the dates for compliance have to be modified in order to be after the date that this court issues the written order. Had plaintiffs chosen to rely on the court's oral order instead of asking to have it reduced down to writing, we would have a different situation, but that is not what they did. So we want to have the appealable order, so that we can then appeal, seek a motion for stay of that order as we got pending in this court. Our position is that this case is currently stayed and that the plaintiffs are actually acting in contempt of the appellate court by continuing to file motions in this court when this case is actually stayed by operation of state law. If we can't obtain a stay from the trial court related to that, we do plan on then seeking a stay from the appellate court, because what we want to do is get resolved this idea that the plaintiffs can simply have this court issue an order telling a sovereign Indian tribe and its gaming entity actions that they have to take on the reservation that would be in violation of the tribe's own laws. As we discuss in our brief, this is a very substantial issue. The case law is all in our favor on this issue, that the court can't simply direct a tribe in a different jurisdiction. The tribe's reservation is not an issue for this purpose. In a different jurisdiction, that the tribe is where its lands are and where it's taking the action that have to take the action the court is ordering it to take, and Wayden would have to take the action the court is ordering it to take on that reservation in violation of tribal statutes and federal law, including the Indian Gaming Regulatory Act and the tribe's laws under that, which provide for exclusive federal jurisdiction. Those are meaty issues. Those are not the sort of thing that we try to use procedural games in order to get a default judgment instead of allowing for the orderly adjudication of those issues. So that's really what we're looking at, is we want a written order that we can then appeal. Once that comes out, we would do that. We would then seek a stay. If we don't get a stay from either this court or the appellate court or the federal court, then we would be in a different situation. But our view is that ultimately we are going to be prevailing on these issues. The plaintiffs don't even have a case against us. Their claims here are frivolous on the merits, but what they're trying to do is get us in a catch-22 where we cannot get the adjudication of issues that would violate the tribe's sovereignty, and that we need to get those decisions before we'd ever go on to a defense on the merits. If we go on to a defense on the merits, we're not going to have any problem winning, because they know that they agreed to a contract that did not provide for monetary relief. And that's one of the things that we find frustrating here, is that we're trying to do what we need to do in order to preserve the tribe's sovereign interests, and those come first. And once we could get those issues adjudicated, then we could go on to these other issues. It's not an issue of contempt. It's an issue of, this is what we need to do in order to protect the tribe from what we view as overreaching by the state court based upon federal case law that we've been working with for decades. And so that's really what we're trying to do. We're not trying to act in contempt of the court. We're trying to get adjudication of the issues in an orderly manner. Thank you.
The first objection to the proposed order is that it doesn't include most of the court's ruling. This is not a requirement. This court can issue written opinions which memorialize the reasoning behind the ruling, or it can rule from the bench, in which case the court gives its reasoning at the time of the hearing. The transcript of the hearing memorializes the reasoning behind the ruling, and then the subsequent order states for the reasons stated on the record. The court ruled from the bench in this case, gave the reasoning behind the ruling, and the proposed order correctly states for the reasons stated on the record. The second issue that the defendant raises is the defendant says some issues were raised by the defendant and were not addressed by the court at the last hearing. That is not a basis for objecting to the order. As a matter of fact, the defendant filed no written response to the plaintiff's show cause request and only raised a barrage of arguments orally at the time of the hearing. The court is not required to address every argument that's raised in that fashion. I will circle back and just briefly address one argument, and that is that this court should disqualify itself. There are two different kinds of contempt. One is direct contempt and the other is indirect. Direct contempt is contempt that's committed in the presence of the court. So in essence, the court or the judge becomes a witness to the contempt. In those cases, there should be a different judge that adjudicates the contempt. This has been treated as an indirect contempt, which is what it is, which is something that the court does not have firsthand knowledge of, but rather relies on, in this case, it was affidavits from counsel. So in indirect contempt cases, the court is not a witness of any sort, and the court assumes its normal adjudicative function without having to disqualify and send to another judge. The third argument is that the defendant again raises several issues that it has repeatedly raised at prior hearings and the court has already ruled on. This is not a basis for objecting to an order. The fourth issue that I'll address is that the defendant seems to believe that there is some improper procedure on the attorney fee issue. There isn't. I properly instructed the plaintiff to submit their attorney fees and costs in writing so that the defendant had an opportunity to lodge a specific objection under Smith versus Corey. That's Khouri. On February 17, plaintiff's counsel properly submitted itemized time entries for Mr. Broder and Mr. Perry, an affidavit from each attorney certifying the accuracy, and the 2020 Economics of Law Practice study. In its February 25 response, the defendant only says, quote, "At the very least, given that this court sanction order is contrary to Smith, this court should order that any sanctions payment should be held in the court's registry," end quote. There is no stated objection to the proposed hourly rate or the reasonableness of the number of hours. Nevertheless, even though there's been no specific objection raised, I do find, first, with respect to the hourly rate, Mr. Broder and Mr. Perry are well-established lawyers at the highest end of the experience scale, and they practice with prominent established firms. It would be reasonable, and I think even generous to the opposition, to place them in the 75th percentile range on the economics of law practice tables. I have considered on the economics of law practice tables, the table 6 for the hourly billing rates by office location, and table 7, hourly billing rates by field of practice. With regard to Mr. Perry, he would be at, for the Lansing area, $345 an hour, and for business commercial litigation field of practice, he would be at $395 an hour. I averaged that to result in a reasonable hourly rate of $370 an hour. With respect to Mr. Broder, he would be at $375 an hour for the location of Oakland County south of M59. And again, the same field of practice, business commercial litigation, he would also be at $395 an hour. I averaged that and came up with a reasonable hourly rate for Mr. Broder of $385 an hour. I have also reviewed the itemized time entries for which there is no objection. I find that there has been no duplication of time between the two attorneys for the plaintiff, and that the amount of time in relation to the matter that the time was expended on is a reasonable expenditure of time. I find that 0.5 hours should be added for today for Mr. Perry. And based on that, for Mr. Broder, who has submitted 12 hours times the 385 per hour rate, his attorney fees amount to $4,620. And for Mr. Perry, he has 4.8 hours plus 0.5 for today is 5.3 times his hourly rate of 370. And that is $1,961 for Mr. Perry. Costs are added in the amount of $40. And that amounts to a total of $6,621. So I'm entering two orders today. The first one is the order that the plaintiff submitted that actually is the finding of civil contempt of court. And I have signed that. And the second order is the order implementing the order finding the defendant in civil contempt of court. And I am just making some adjustments to that to reflect the hourly rates for the attorneys that I calculated today. And that will reflect the $4,620 for Mr. Broder, the $1,961 for Mr. Perry, and the costs in the amount of $40. And I've amended that order accordingly and changed the hourly rate that had been put in the suggested order according to my ruling today. And I have signed that, and I'll have both of these entered with the clerk. And that will conclude our hearing for today.
Your Honor, I want to ask for reconsideration on 2 points. First, our argument regarding the $1,500 was that the court didn't take those documents for the $1,500. The court is now adding additional sanctions based upon an order that was improperly entered regarding the $1,500. That is our discussion of Smith versus Corey, is the court didn't require any of that for the $1,500, and in fact didn't even allow me to respond to the $1,500. And so that was the argument there. Our position also is that the issue regarding additional attorney fees is not noticed for today. The notice for today was originally issued on the 14th, and the plaintiffs then filed these additional documents after that date. There's no notice for a hearing on their request for attorney for that motion. They tried to slip it in as a supplement rather than as something where they noticed it for hearing. If the court were to look at Smith versus Corey, it would actually find that the plaintiffs have failed to meet their burden under that statute for the new fees, at least at this point, because the rate within the locality is just one of the factors, and Smith versus Corey clearly says the plaintiffs have to also have the burden of production and proof on the other factors. So had they noticed the issue for today, we would expect the court would have then obtained briefing on that, and it would have rejected their request because they didn't meet the required factors. But our primary objection is that this wasn't noticed for today at all.
That is not a proper motion for reconsideration under the court rules, and I will decline to address it, and that will conclude our hearing